Lord. I'm concluding my submissions in respect of ground 5 and on this appeal.
Yep.
And I have identified the factual matters.
Yep.
And was moving on and began to move on to the judge's analysis of the shaving allegation. And on the basis of those matters to which I have brought the court's attention, the task for the judge, we submit, was not the fact of shaving, but whether the shaving was undertaken with a sexual motive and in the way in which H alleged. And the subsidiary question the judge asked herself was whether the allegations made or the account given by S corroborated that allegation of H. She says as much at paragraph 82, page 69 of the court bundle, where she says it appears to be the one issue on which there is corroboration.
Yeah.
She says the account H gave was supported by a separate account given by S.
Yeah, we looked at that this morning. Yeah.
And our submission is that is wrong.
Sorry, Mr. Timmy.
Well, I've already spilt a glass of water this morning, so.
1-1 then.
Yeah. So you say the judge was wrong. It's not corroborative. Understand that.
Paragraph 83, just illustrative of the point, whether they may have colluded in fabricating these allegations. Well, arguably S wasn't making an allegation. And the reference there is to her notably denying that she was ever subjected to any other sexually abusive behaviour. She did not complain of any sexually abusive behaviour. The starting point in this case was, as the judge identified at paragraph 77 of her judgment, that in respect of H, whose allegation she was trying, for there was no allegation of sexual abuse of S, paragraph 77, H is capable of giving a clear and reliable account of events, but she is also capable of exaggeration, telling lies, even when the consequences for others are extremely serious, and even when faced with incontrovertible evidence which demonstrates her lies. The ultimate analysis is found at paragraph 104 of the judgment, in which the judge says, in relation to the allegation about shaving H's legs and armpits, there is evidence from S which lends considerable support. And we say again, she is wrong about that, for the reasons I've already set out. Over the page, for instance, it's repeated in the conclusion, I prefer the accounts given by H and S that he repeatedly insisted on coming into the bathroom where they were showering and shaved their armpits and legs when they were naked. Then paragraph 105.
So you say wrong in that is that repeated, and so far as S is concerned, it's insisted.
Insisted.
And showering,
shaving legs.
And legs.
And naked.
And naked. So wrong on 4 counts as far as
yes.
S is concerned.
And of course that's of those 4 counts or those 4 particulars are highly significant when she's seeking to determine motivation, whether it's sexual or benign. We have passed up over lunch and to the parties a document that was before the court, which is a statement of a woman who gave evidence to the court. It's in fact, so it's Miss E. It stands K7 in handwriting G1 at the bottom. It's the very last paragraph on the last page, where this witness explained that S had not told her anything sexual ever happening to her. However, she has told me that he would shave her under her arms to teach her as far as concerned. But the complaint was shaving under the arms to teach her, which is in line with the parents' account and indeed the mother's account. It's the mother's account then I turn to and the judge is dealing with that issue at 105, page 80. She reflects on having found, again, the girls, the apostrophe beyond the S, accounts of shaving and showering. I have reflected on whether the mother was aware that this was occurring and allowed it to happen. I'm conscious that neither mentioned their mother when raising these allegations, and neither specifically alleged their mother was aware of his actions. So key to this finding, key to this issue was her finding that the children had not referred to the mother, and that was an error. In the light of this, I am satisfied there is no evidence to support the suggestion that the mother was aware of this abuse occurring. Where does this leave me with her account? I can only conclude she deliberately lied to the court, either of her own volition or in respect of her husband, at the request of her husband, to undermine H's claim.
So the part which was the error in the second sentence, second sentence, is what?
The error is that S was very clear that she says it twice in the interview.
Because S had mentioned it to her mother.
Yes, twice.
S, yes.
Yes.
Not H.
Not H, no.
That's right.
And of course H, well, H is describing very clearly a course of conduct, part of which was this shaving. She's describing very clearly a course of sexually abusive behaviour. The man forcing himself into the bathroom when she's showering naked. S is describing something completely different. Of course, it might have been open to her to consider the fact that S described this happening on occasions without a top. You'd have to consider what that meant. Was she naked from the waist upwards? But even if she was,
so your point of view on this case, on this round, is that the reliance on S is integral to the finding, and therefore the finding. So
yes. And we say there was no consideration on this issue of, in fact, S's account pointing the other way. It's not just a lack of corroboration for H. It points the other way because she gives no evidence of coercion, no evidence of him walking in on her in the shower, and gives evidence, positive evidence, of her mother knowing about it. So, in fact, it points the other way. Of course, finally, S was not cross-examined. One can see that in any event, as I said, at the end of 104, the overwhelming point is made that she'd already made a finding of sexual abuse against the father. But also, those are my submissions on those grounds. Unless there's anything further I can assist the court with, I will turn briefly, if I may, to the issue of clarification request. The request for clarification was on the lengthy side, and I think we will accept that it was too long. What the advocate must do in these situations is balance, on the one hand, the criticism he will face potentially from this court that he has not raised something before the trial judge that he could have raised. And sometimes there's a tendency, out of an abundance of caution, to make it clear, particularly when presenting draft grounds for appeal, the court, the trial judge, with the opportunity to say, well, that's not what I meant. In this case, we accept it was too lengthy, but it's right to say that this court might feel that some of the references in the judgment are opaque. It's our complaint about the judgment that there are a number of factual errors. And it's our complaint about the judgment that things were not taken into account which should have been taken into account. So to that extent, on a fact-finding appeal, particularly, it can be difficult to draw that line to to make sure one has given the trial judge the opportunity to respond fairly to a complaint, which shouldn't simply be channeled directly to this court. But we would accept on this occasion that it was too lengthy. Can I say that the only other matter I wanted to raise is that whether the court considers that in fact it's helpful, perhaps, if not necessarily raising a request for clarification, is it helpful for an advocate who believes he has grounds for appeal to have drafted them, to present them to the judge, so that when that judge is considering an application for permission to appeal, the judge knows exactly what's there. And of course that then might prompt the judge to clarify things that aren't.
Well, I think that's where the potential muddle comes in.
Yes.
You're completely right that if you're asking a judge for permission to appeal, it's hugely helpful to have written grounds of appeal. And a judge should be asked, because then he or she can give their answers, and sometimes a judge can answer something by making a point that's possibly not within the judgment itself, but is an answer which ties in with the judgment, and this court has said you have to read both together, and that's perfectly acceptable. But that's all on the basis that the judgment is, to all intents and purposes, done. And I think that comes at a second stage. I also agree with you about factual errors. If there is something that is regarded as a significant factual error, then those ought to be pointed out. But I think that the middle ground, all too often, these exercises can become an exercise in point scoring. I'm not saying that completely describes what happened here, but certainly in the ones that I've seen, and indeed not very long ago, I think I was sitting with my lord, there was a clarification exercise which actually turned up the key point, and it was so rare in my experience I commented on it.
You did.
So that was the exercise working, but I think that the lines ought to be reasonably clear.
Could I just add this? In this court, and I think in the division, there's the practice, and other divisions, High Court, there's a practice of sending out draft judgments. Does that happen at circuit judge level? Draft judgments. Because we send what we send out our draft judgments, and what I did I was in the division, sending out a draft judgment. That's the point for typographical and minor factual errors to be corrected.
Yeah. That does happen, although there is now, because of the pressure on the lists, I think one court now in particular is saying that, I think it's East London, is saying that cases have just got to carry on and finish. So the expectation is finish with a judgment. So
nothing reserved in East London?
No, well, I don't know.
Not much.
Perhaps I put
Yeah,
it
well, we
too-
understand the pressures.
But there is pressure to
we
get
understand.
the judgments out.
And I know we've been quite strict on clarifications, but you're right to make the point as elegantly as well as you do, Mr. Toomey, that it's a difficult judgment for the advocate.
And may I say that also goes for cross-examination sometimes, the extent of.
I've already acknowledged that.
Can I assist the court any further?
Really, thank you.
No, thank you very much, Mr. Toomey. Yes.
My Lord, we have discussed over the lunch and adjournment the allocation of time. I'm probably going to be about 40 minutes, and then leaving Mr. Tyler and Mr. O'Brien about an hour and a half. This is what I hope. Obviously, that's subject to any questions and other matters that you wish to raise. My Lord, could I deal with the appeal in this way? Two sections. The first section would group together the findings 2, 3, and 4, which are the failure to protect and risk findings, and the mother's inability to manage risk, as the court found. And then separately, the issue about mother's treatment of H and the significant emotional harm arising as a result of that. In order to deal with the failure to protect aspect, could I take the court straight to the learned judge's judgment, in which she deals with the case, the well-known case of re L and W, which of course my Lord Lord Coulson appeared in and was involved in, and really just deal with paragraph 33 on page 50 of the core bundle.
Yeah.
Now, there's no suggestion at all that the learned judge has misquoted the LW. It's clearly set out. But I noticed, just on further preparing this appeal, that paragraph 64, as she is quoted, stops at the word inevitable. But that paragraph goes on.
Have we got it?
I'm afraid not, my lord. I'm just going to, with your permission, just read this section and refer you to read LW in due course. It just simply says this: as Aikens LJ observed in Read J, nearly all parents will be imperfect in some way or other. Many households operate under considerable stress, and men go to prison for serious crimes, including crimes of violence, but are allowed to return home by their long-suffering partners upon their release. That doesn't mean that for that reason alone, that parent has failed to protect her children in allowing her errant partner home, unless by reason of one of the facts connected to his offending or some other relevant behaviour on his part, those children are put at risk of suffering significant harm. And my lord, really, in other words, there needs to be something that supports a causative link, such that the mother ought to have known that the father presented a risk of abuse to the children. And there is one authority in the bundle which I'd like to go to just to demonstrate how failure to protect is properly applied to in cases of this kind. And it's in the authorities bundle. And it's the case of Re JS. And my lord, it's at 304. So the PDF page reference in the authorities bundle, in fact, it begins at 300 is the. Now, the section I would like the court to look at in due course is, as it happens to be, the then Mr. Justice Baker and his application of failure to protect. But it's a case involving.
Just give me the page reference in the bundle.
It's 300 where he deals with the failure to protect aspect.
Paragraph.
And it's paragraph 133 onwards.
133.
Yes.
Firstly, the paragraph starts firstly.
Exactly.
Yep. Yep.
And my lord, just to give you the context, this was a case in which Lord Justice Baker found that there was a head injury to the child, and it was caused by the father, not by the mother. And then he went on and dealt with failure to protect, and he dealt with it in four parts essentially. Firstly, he found that the mother knew of the father's violent and ungovernable temper. That's in paragraph 133.
Yeah.
And she exposed Jay to his overnight care on a regular basis. So clear finding of knowledge and then inaction. Then paragraph 34, my lord found that the mother was also culpable of failing to protect all of her children from the emotional harm caused by being exposed to the father's ranting and explosive temper. So not just the physical harm, but the emotional harm. Again, in the knowledge that this was a man that had an explosive temper, and she had seen this. Thirdly, the mother failed to seek medical help after the 2 episodes. And again, a physical failure to do something in the knowledge that. And then finally, paragraph 136, I find that the mother failed to give any information about the funny turns, either to the health visitor or the GP. And again, she had plenty of opportunity to do that. So physically didn't tell the health visitor and the GP about the child's change in presentation. And finally, to be fair, there's the mother misleading the police and social services and the medical staff about the father's history of violence. So knowing again really serious, relevant information and then not sharing it. And of course, rightly, in my submission, my lord found that the mother had failed to protect for a range of reasons. Now, let's look at this case and the facts that the judge faced and how she dealt with it. And I hope I'll deal with it relatively briefly.
So you hold up my lord's judgment as this is how you do it?
Yes.
Depending, of
Yes,
course, on the evidence.
Yes, precisely. And of course, I completely accept, my lord. Every case is
evidence will be
dependent on its own evidence.
Yeah, but you say that's something for the court to bear in mind.
Yes. And what we have here is, of course, and I'm going to really just take you to the judgment in sections, and I'll quote paragraph numbers to help. But the broad brush point is that this was a learned judge who looked at the evidence, and you can see from paragraph 122 of the judgment, and I'm just going to take you to the nicely framed findings, which are at PDF 87 and 88.
Yeah.
And my lord, you obviously have all the non-findings, the allegations of sexual, alleged sexual abuse on H that was not found, but there is clearly the finding about the bathroom and the shaving and the showering against her wishes.
It's 2-2 on 98, isn't it?
Exactly. And the learned judge then goes on to say that it wasn't proved the mother was present in the home when H was raped and sexually abused. We now know that she didn't find that H had been raped and sexually abused. And then 2(2), as my lord says, the mother was aware of the previous allegations of sexual harm and failed to take appropriate measures, not proved, she says, as at the outset of the relationship, but following H's allegations. Now, this is a crucial point to our appeal, because the learned judge then goes on and says the mother failed to consider the possibility that H or A's allegations may be true and failed to take any precautions to address any risks posed by the father. Now, when one looks at what that really meant in real terms, one needs to just look in very basic terms at the chronology. The learned judge found that in fact the mother had not failed to protect at the outset of the relationship, even though she knew about the allegations in relation to A. She failed to protect when H started to make allegations, and she failed to take precautions. But the reality on the ground is this, that H actually had left the home some 2 weeks before she made the allegations in the first place. She'd left the home in mid-December, and the allegations were made later in December, so she wasn't physically in the home. Secondly, and importantly, the father was arrested and then remanded, and I think released sometime in February, so that the father wasn't in the property from really the date that H had made the allegations onwards. So there was no unsupervised time, for example, or showering or being in the home, taking the children to school. He was allowed to have contact, but that contact needed to be supervised. And so, my lord, there was essentially no precautions that needed to be taken in relation to any risks posed by the father, because on the ground there just wasn't the practical issues. Now, my lord, secondly, and it's the point about knowledge and comparing it to Re JS, this was a case in which the learned judge, after, in my view, a very careful consideration and review, and rather sophisticated review of the evidence of H, came to a number of conclusions about her credibility and reliability. My lord, one needs to only look at 3 paragraphs. Paragraph 74 of the judgment deals with one of these important background credibility points. And it's to do with the maternal grandfather.
Give me the page again. Sorry.
Absolutely. It's 66 of the core bundle and paragraph 74.
Thank you.
This is the allegation that H makes in relation to the grandfather, that he had pushed her and hit her across the face during an argument. And when one looks at this in very careful detail, one sees that in fact the judge prefers the evidence of the grandfather over the evidence of H. So rejects essentially the serious allegation that H makes that the grandfather hit her across the face, which is clearly a criminal assault. And then she goes on and looks at the lie in relation to the unknown male in the bus, which is paragraph 75 on the same page. And again, she concludes that she can't rely on H's evidence about this. And later on in paragraph 99, she says that this is a child who can be open and honest, but can also lie in very sophisticated terms. And then the final is in relation to the mother, because this all began because H made an allegation of physical assault against the mother.
Yeah, in December.
In December.
Yeah.
And in paragraph, I think, 56 and 57, again, I say in a careful way, the learned judge sets out the background to this, PDF 58. And then records fairly, in my view, the fact that the mother denied this, and so denies essentially physically assaulting her own daughter. And obviously, if that was a lived experience and the mother had been attacked by H, then the court needed to determine that, and the court did, in fact, determine that on a binary basis, and that is in paragraph 94, page 75 and 76. And again, I applaud the judge for the careful way in which she carries out that analysis. But she was unable to find that it's more likely than not that such an assault occurred. And my lord, on obviously a binary standard, it must be treated as if it has not taken place.
That's the judge. That's from the judge's perspective.
That's from the judge's perspective. Absolutely, my lord.
That doesn't apply. To what extent does that help us evaluate the mother's reaction at the moment H's allegations were made in the context of A's allegations? The mother doesn't carry out an analysis leading to a binary conclusion, does she?
My lord, you're quite right about that. But what the mother does say is that that assault never happened.
Mhm.
And I did not experience what my child says took place in relation to an assault which apparently I inflicted. And so it follows that she's lied about that, and she's lied about the grandfather, and she's lied about the man on the bus. I don't believe her. And I think that's part of the thought process.
Well, the finding the judge makes is the mother failed to consider the possibility that H's or A's allegations may be true. And I think those must be the sexual allegations. That's
Yes.
the finding against which you're appealing.
Yes, and it's against the background of obviously the mother's very clear view that H lies about very serious allegations, that she was not able to accept that the father posed a risk on the basis of H's history and H's lack of truthfulness. And of course, at that point, we had the allegations in relation to A, which had been part of the criminal proceedings. And my lord, the learned judge found that faced with the history of the lack of a conviction, the allegations but without the conviction, the court couldn't find that, in fact, the mother had failed to protect H at the outset of that relationship. And she went on and obviously developed that and said, well, when H made the allegations, at that point the mother wasn't able to accept the risk and contemplate it.
Well, failed to consider the possibility.
Yes, and then went on and said that she hadn't considered what safeguards, if any, and I hope made my point about the practicalities and the physicality at the time. So, my lord,
I mean, all this is relevant going forward, isn't it? This is why this is particularly important in this case.
it is, my lord.
Am I right that the younger children are with your client?
They are under interim supervision orders and without.
So that gives, and that whole framework gives helps us to map out the importance of these findings.
Yes.
And the question here is, which I was looking at, is risk going forward, and her finding is that your client failed to consider the possibility.
Yes, and my lord, I think the difficulty is this: that there were no findings in relation to A at the time in the criminal context. There were no findings at the time that H made the allegations in 2022. But clearly there are findings now in relation to A and also in relation to H, insofar as it deals with the inappropriate sexual shaving. And so that's a current finding, that's a finding at the end of the fact-finding process, rather than at the relevant time when obviously protective measures were taken. And I think that's...
I mean, there weren't, in JS, there weren't findings against the father.
No.
At the time, the question of at the time at which I had to evaluate the mother's failure to protect. Completely different set of facts.
Yes.
Of course.
But Your Honour, there was knowledge and the factual acceptance that the father was violent, that he was exposed.
So it's a different set of facts.
Yeah.
But it's frequently the case, isn't it?
It is. It is, and my lord, that's one of the reasons.
That you don't, my point is, parents, when they're evaluating the risk to their children, don't conduct a forensic exercise to determine whether, on a balanced probabilities, this child.
Yes.
Nor do they say, well, there's a significant or real possibility. They just take steps what are necessary to protect their children. And what the judge was finding here was that your client didn't consider there was any possibility, or failed to consider there was any possibility, that the allegations might be true. That's the point, isn't it? You failed to act protectively as a reasonable parent would. I'm paraphrasing how I read her judgment.
So, my lord, I think if the father had remained in the home, and if the father was having direct contact, that would be very different. But he was out of the home. the allegations had been made after the child had left home. There was no issue of risk, if you like, on a.
So your point there is different point. Forgive me interrupting you, but
Not at all.
your point is that in that context, the fact that she didn't consider it possible did not amount to a failure to protect, because the child was protected by the other circumstances.
In part, yes.
Can I just ask about the the allegation against the grandfather? Because I think I understood you to say that the judge's conclusions on that matter,
Yes.
which are dealt with in paragraph 74, have a bearing on the mother's approach to protection of H. And I hadn't really picked up where we get anything about what the mother knew or thought about those allegations.
Well, my lord, my instructions are that the allegations were obviously in March of 2022.
Who made to the police?
Yes, and so at that point, of course, the father was still on the scene. H was still around, and this was not the time when, for example, the allegations of a sexual nature were being made. So the mother was aware of those, and those were explored. But obviously, it was the learned judge at the fact finding that dealt with the.
Well, I thought the thrust, I'm putting this much less elegantly than you have, I thought the thrust of what you were saying to us was the mother knew that this was a young woman who was capable of telling lies.
Yes.
And what I'm asking is, where do we get the evidence that the mother thought that what had happened in relation to the grandfather was evidence of H telling lies? We can see that
That definitely comes from the judge's judgment, because she was not present during this altercation. This must be as a result of the judge having evaluated H's evidence and compared it to the maternal grandfather's, and the judge obviously preferred the grandfather's evidence. In relation to
and that goes back to my lord's question. How does that help us when considering the mother's approach when H made the allegations of sexual?
My lord, it doesn't at the point that H made it, but of course what the learned judge then does is, in her judgment, deals with the mother's views and approach at the time of the fact finding. So she gives a judgment in 2023, which obviously looks at the now rather than the point of time. But my lord is quite right, that if you were to take a photograph of that, a still shot of December 22, that was not an issue that had been determined at that point. My lord.
I mean, do you on the facts? Forgive us. I'm
Yes.
sorry, it's not helpful if we bombard you, but
Not at all.
can I just ask you on the facts? Paragraph 111. Do you accept the first sentence was the judge was open to the judge to find that on the evidence? At no stage has the mother been prepared to consider the possibility that H's allegations may have been true.
My lord, that is based on the mother's refusal to accept that H was telling the truth. And so that was a fair description of the mother's position, and it's a fair description of the mother's position currently, because obviously this matter is before the appeal court, and the mother doesn't at this point accept the court's findings.
So really, reiterating the point I made earlier, your case is it's correct that the mother did not accept the possibility that H's allegations were true. In circumstances of this case, that failure, if it was a failure, did not amount to a failure to protect.
Yes.
In all the circumstances.
And my lord, I think just to have a hook to hang this on, of course, the starting position often is that there needs to be either an agreed factual matrix or a narrative determined by the court. So the, if you like, the harm, and then one can look at whether or not there's a risk of that harm taking place again, and then what safety procedures or safeguards can be put into place, and can the mother in this case manage the risks. And so in order for the risk to be properly assessed, one needs to know what the harm was and if that harm is likely to occur again and in what circumstances, what are the triggers. And the difficulty with the binary position is that one needs the factual matrix first, the fact that something abusive has happened and the reasons behind it, or very clear triggers that may lead to harm that hasn't yet taken place, but for a range of different reasons, for example, attempts or material found on a computer or words and phrases seen elsewhere, that there is a sexual interest in children, which hasn't been acted on. So I think it's the fact that at this point, there was no conviction, there was no factual decision, and the mother was simply expected to put together safeguards and protection for a child that was no longer in placement, for two children who were, but who had no contact at that point at all to the father who wasn't even living in the home. The learned judge was fair because in order to decide and conclude that the mother had not failed to protect when the first A's allegations were being litigated or looked at, and that she continued, if you like, to protect until H's allegations much later, was that she accepted that the mother had, for example, refused to move in straight away with her father, that had made inquiries of friends and family, and had carried out her own, as my lord says, her own, if you like, crude, unsophisticated, but very real risk assessment. And so she found that that was the case right up to Hannah's, H's, pause that for a moment. Right up to H's allegations. And then, of course, what then followed was in a very different practical context, as I've said. Your Honour, the other, my Lord, the other short points of these is that we have I think a description by the learned judge of a number of things that concerned her about E&T, because she then went on and decided that E&T were at risk in the mother's care, not just the father's care, but actually in the mother's care. And of course, E&T lived with the mother, and they hadn't lived with the father, and they weren't living with the father at the time that the findings had made. I completely accept, in light of Her Honour's finding that A had been sexually abused, if father had remained in the property, then of course those children were at risk of harm from the father. But they couldn't be said to have been at risk of harm from the father based on the scenario that the court found itself in 2023.
What about through contact?
Because that contact was always supervised.
Well, at the moment it is.
Yeah.
I mean, paragraph 113 is the key paragraph, isn't it?
My Lord, I'll just
I'm concerned the mother's been incapable to date of accepting even the possibility that father might pose a risk to the HE&T. Given my findings, I require, etc.
My Lord, that's right. And I think the point that we make, and it was repeated by the learned judge, is that even hypothetically, she's not prepared to accept that the father may pose a risk. And that was on the basis, obviously, of a lack of findings at the time. No findings at all, simply allegations, and we know that almost all of the allegations that H made have been not proven, and I'll come on to the showering and shaving episode, which is serious, and I'll come on to dealing with that. But my Lord, at the time that the learned judge had made that observation, of course she had just made the findings in relation to A for the first time. And my Lord, the reason why we at times, and I know that it should be the exception rather than the rule, invite the court to case manage and to direct that a fact finding should take place before a welfare evaluation is that there needs to be the findings of fact and then a period of reflection and absorbing of the judge's decision and then an evaluation of that, followed by a risk assessment. And the reason why in some cases the so-called either-or risk assessment, which is something that takes place in tandem with the evidence gathering and the fact.
You want to explain what that means?
Yes, my lord. The either-or assessment came in a few years back, where the court would direct that a psychiatrist or an independent social worker will carry out an assessment of risk based on either
Alternative
one set of
proposition.
findings or the other. And it was never satisfactory in certain cases where the allegations were of a, for example, inflicted injury or sexual abuse, because it mattered, the context mattered, the triggers mattered, and the overall wider canvas issues that are often in these cases have to be looked at. And key to this is that there would never have been a period of reflection on what are seismic or monumental findings. And of course, one of the fair findings that this judge made, or non-findings, is that the mother was not aware, in this case, of the abusive showering and shaving. And so she was not aware of that. She wasn't aware of the alleged acts of sexual abuse within the home. And so she wasn't directly aware of anything. And the question, ought she have been aware, I think is preceded by the fact that there was a lack of findings at this point at all of any kind, either in the criminal context with A or subsequently with H. And so the findings are now, and of course if this court decides that in part the appeal should not be allowed and the findings in relation to A stand, even in relation to H and the showering, and we invite you not to do that, but if you do, then of course there now needs to be a line drawn under this, and for the mother to look at and to reflect on the judgment and to absorb this for the purposes of an effective Part 2 risk assessment. Now, Mr. O'Brien, and I agree with him, makes in his submissions the fair point that it's for a judge to evaluate risk ultimately. It's not for a psychiatrist, it's not for an independent social worker, it's not really for the parent. It's the learned judge that looks at everything holistically in its totality. But often judges are given the benefit and in fact benefit from expert assessments. And my Lord knows, Lord Justice Baker knows all too well that in cases of abusive head injury, for example, where there have been multiple episodes of inflicted injury, there's usually a forensic risk assessment. And of course, the judge benefits from that to see whether or not there was psychiatric or psychological triggers or reasons. Now, in this case, of course, the findings were made, but the judge then went on and simply evaluated what she saw and heard from the mother, essentially. And one point which I was, one of the only points that I raised about the judge's lack of fairness in relation to observing matters is in paragraph 112, which deals with, I think, demeanour.
The demeanour point.
Yes. I won't say I was concerned about that. I just make an observation that she read possibly too much into that. And I know that this court has cautioned about over-reliance on demeanour, and I know that in cases even evaluating expert assessment, demeanour is an aspect that one needs to look at. But in this case, the learned judge says on page 82, PDF 82, I was keen to observe the mother's paragraph 112 response to the evidence of A and Miss W to see whether that might bring about any change in her position. The mother appeared completely detached from the proceedings, when that evidence was being heard. She sat motionless, staring into the distance. Now, my lord, I don't know what it was that the mother was thinking at the time, but I think it would have been a strain for this learned judge, who had, I think in many ways, been very fair in her analysis of a lot of the evidence, to draw a conclusion.
Do you
from
say that was a critical part of her judgment, or just
No, I don't. It's
you
just
wouldn't say
aspect.
that fact, that
No.
observation alone?
No,
Just-
but it was an aspect of her. I'm going to call it lay assessment of risk, because
So
of
not
course she's,
sufficient by itself to
No.
justify.
and she's quite right. I'm concerned that the mother, and my lord has read this important paragraph. I'm concerned that the mother had been incapable to date of accepting even the possibility that the father might pose a risk of sexual harm to H, E, and T. And I've tried my best to try and explain that the reason behind that is the absence of findings, that the number of issues about her truthfulness, including the allegation that she had been physically assaulted by her own mother. Why would she then accept that she'd been sexually assaulted by the father when she firsthand will tell the court that she hadn't been physically assaulted by her mother? And
Well,
so,
if it's of any help, I'm bound to say, speaking for myself, I thought 112 was unusual.
yes,
And you've made your submissions about it.
Yeah.
So again, speaking for myself, I'm unsurprised that you make a point about 112.
thank you. And so, my lord, what I say is really these were findings that were made at the fact-finding stage. If they remain intact, then obviously there needs to be a proper risk assessment, part 2, based on those findings, and an acceptance that those findings on appeal, and we know that there was at least an arguable grounds for an appeal, so the mother can be forgiven for having some degree of optimism that there are arguable grounds. Now, if this appeal is not allowed on various grounds, the mother will have to look at those findings, and there needs to be a part 2 assessment. But the danger was trying to carry out an assessment, and I'm not going to call it improvised because it wasn't. It was done at fact-finding stage using what the judge had and the limitations that the judge had, but against the background of no findings at that time. So, my lord, I hope that deals generally with the main points of our appeal. The second lot are not as attractive, and I looked at those with some care when I took over the case. These are the issues about the mother's treatment of H. And I think if I'd seen this in the cold light of day, I would have said that, for example, putting the phone down on a teenager in the context of the teenager saying that she didn't want to come home, the mother having a young baby, would not have triggered, for example.
But all this is surely all these points are in the sphere of the judges in the best position.
Well, I think that's what I'm coming to. I think probably this is not our best grounds of appeal. I don't think that this local authority would have issued based on a phone being put down or a delay in personal effects being handed over. I think the lack of contact is serious. I think that is an important point. The mother explains the lack of initial contact. The judge didn't accept the mother's version of events, and I think, to be fair, I think looking at it in the cold light of day, I think it's difficult for me to say that she exceeded the wide ambit of her discretion in relation to that point.
There's going to be so
But that will be
assuming
for
that
welfare.
that stands, you accept that fine in that context, you accept that we're likely to not to interfere with that finding.
Yes, I think I have to be.
So to that extent, at least, there will have to be an assessment.
Yes, yes.
And your client will have to build then on the very positive things about her care of his children,
Exactly.
in order to be in a position to persuade the judge that
Exactly.
she should continue to look after.
And the sort of points that my lord mentioned earlier under the arguments about good character, the wider canvas considerations. But my lord, obviously, if this court interferes with the findings, the main findings against the father, and also the findings in relation to failure to protect, that will change the complexion of the Part 2 assessment. If the court keeps intact
Yeah, well, that's
the
a matter
findings,
for, all that'll be a matter for the judge.
absolutely.
to
But
determine.
if the court maintains the findings in relation to father, but accepts the points I make about failure to protect for the reasons that I give, again, that will change the complexion of the Part 2. But I'm not going to advance the grounds in relation to ground 4 and the findings 5. My lord, in relation to the showering, the only point I wanted to make, a short point, is the learned judge found that the mother was not aware at all, and that had essentially made up a story in order to help the father. Now, I know that A claims that the mother was aware of the shaving.
S.
Yes.
Sorry,
Yes.
S. Sorry, I meant S.
A was 2008.
Yes, correct. S. And I know that the mother's case was that there was an episode. It involved a bathing costume. She was present, and it was essentially shaving the back of the legs. But the point that's being made is that H was obviously not called to give evidence, so we couldn't ask H anything about the showering episode. She mentions the shaving. She doesn't mention the mother. The judge was quite right about that. But she was never asked whether or not her mother was present, how many times. And so the learned judge has concluded that because H never mentioned the mother, it was likely that she wasn't there. And I don't think she was entitled to go as far as that. And of course, that's one of the difficulties when, on the correct basis, the child H did not give evidence. And so we couldn't ask her about an innocuous event in which she was being trained how to shave the back of her leg in the presence of E and the mother. But my lord, the learned judge made the finding that we weren't aware even of the act of shaving, and we will leave that intact essentially. I don't know whether there's anything else I can assist you with, my lord.
No, thank you very much. Thank you very much. Yes, just to find the... Yes, Mr. Tyler.
Well, Lord, thank you. There is much for me to deal with, and time is perhaps slightly against me. I know I will be moved on or redirected by my lords.
Well, we've read your skeleton argument obviously carefully, so you can take that as read and use the perhaps slightly less than an hour and a half, hour and 20 minutes, shall we say, wisely.
Well, thank you. Well, can I begin by making three, possibly 3.5 general points? Number one, the difference between the jurisdictions. I know my lords will have read and be familiar with Lord Justice McFarlane's judgment in Re R, supplemented as it is by Lord Justice Hickenbottom. I wonder if I could just direct the court, please, to Re HN, which picks up on that. It's authority number 21 in the bundle, at page 616.
This is the domestic abuse case.
Well, yes, it's the conjoined appeals in relation to domestic abuse and their handling. But at section 4, there just above paragraph 60, Lord Justice McFarlane deals with the relevance of criminal law concepts, points out the difference between the purposes of criminal law and the family court, deals with the degree to which the family court, if at all, should have regard to and deploy criminal law contexts. quotes from himself in RIAR, which points out rather more graphically and in more detail the difference between the fact-finding investigation and its purpose in a children case and a criminal trial for an offence. Reminds the court of paragraph 64 that Lord Justice Hickinbottom concurred with that view in RIAR, describing himself to be very firmly of the view that importation of concepts from the criminal courts into the family court is inappropriate, unnecessary and unwise and should be avoided. Then makes this point of paragraph 65 that there's a distinction between, on the one hand, a judge needing to have a sound understanding of the potential psychological impact serious sexual abuse may have on a victim's behaviour during and after the event in the way they give their evidence and present in court, and on the other, the danger of family court judges being drawn into an analysis of.
This is all about whether the court should make findings of rape, isn't it?
In this context, in RIAR, it was about an unlawful. Well, it was about a killing, and whether.
Yeah, okay, but in AHN it's about rape.
Yes.
So that's about the criminal ingredients of an offence, isn't it?
Yes.
And that was what Lord Justice McFuck, the president, was by this point. I think. Was it the president? Yes. Was saying in HN.
In HN, in R, it was more general about the
Yes.
disadvantage of trying to bring criminal law concepts into family court cases.
Or was it, the case had nothing to do with the law of evidence or how juries should be directed in criminal cases, or about manslaughter, wasn't it?
Well, yes, well, it was about the danger of being drawn into concepts which are relevant to criminal assessment of guilt in family cases.
Yes.
Whereas
So
the need.
what we're talking about in this case, I think, is the assessment of evidence,
Well, yes.
which has nothing to do with guilt, for instance. It's about the relevance and admissibility and weight of evidence.
Well, yes. Paragraph 65, I've just taken the court to, deals with the understanding of victims of sexual violence, and the paragraphs I was coming to at 67 and 68 set out the President's assessment or description of and assessment of the importance of the particular training that, for example, family judges receive in relation to that difficult part of the assessment of evidence. So the general point we make perhaps starts off as being too obvious to require stating. There's a vast difference between the roles of the family court judge in fact-finding and the combination of roles of Crown Court judge and juror. We also, as part of this general point, make reference to a point tangentially referred to by Lord Justice Baker in relation to the authorities that stated if a judge has correctly stated the law, the judge can be taken to have correctly applied that law unless the opposite is shown. Two of the judgments, for example, in the authorities bundle, Lord Justice Baker's judgment in JS, Mr. Justice MacDonald's judgment in Re-P are hugely lengthy, extremely detailed judgments setting out with great detail the relevant law. Our point is simply this: judgments of that length, judgments with that degree of analysis simply are not possible in the context of the busy lists of circuit judges operating in the context in which they do. So that's point one. Point two, and this has been referred to, I suppose, by my Lord Justice Coulson. What sort of case is this, or what sort of case isn't this? The way it was presented in submissions to Honourable Judge Thain, in the application for permission to appeal before her, before this court, in early skeleton arguments, even in the later skeleton arguments, is that this is effectively a classic historic sex abuse case. It is not. This is not a case in which a defendant or respondent is confronted for the first time with historic complaints years and years after the events that the complaints are said to encompass. Here there was an absolutely contemporaneous complaint. So the day of the final alleged incident was the day on which A told her mother and was taken to the police and gave her a BE interview. That was the day on which the father was arrested. He was interviewed the following day. So there was entirely contemporaneous researching of and preparation of his defence, entirely contemporaneous availability of legal advice and representation. So for sure, the passage of time between Judge Thain hearing the case and the index allegations is significant. But much of the disadvantage, which we would say underlies the reason Crown Court judges are encouraged to give the directions they do to juries, simply don't arise in this case. The assertion that the appellant has been prejudiced or disadvantaged because of the passage of time, we say requires real scrutiny in this case. We don't accept the broad assertions in relation to that disadvantage. Point 3, I hope I can deal with in one single word. It's this, Pigloska.
You say Pigloska, I say phage, because phage contains the all-time brilliant sentence that the trial is not a dress rehearsal, but the first and last night of the show. And with great respect to the judges in Pigloska, that point is not made with that clarity and precision. So as I say, you say Pigloska, I say phage.
Well, I'm happy to change my single word for
Yes.
point 3.
We have been steering towards phage in the family appeals, because phage, what Lord Justice Lewison said in phage and in Volpe, encompasses what's in Pigloska and expands on it, and as my Lord says, expresses it in a clear and cogent way.
Yes.
Your point is leave it to the judge. We should not, we must exercise judicial restraint interfering with findings of fact and the inferences drawn from them.
Judge Thain spent 10 days hearing evidence. Whatever is right about demeanour in the same courtroom as those giving it was absolutely immersed and submerged in the papers and the detail. Couldn't possibly express every nuance of why she reached the decisions that she did. And if this court repeatedly reminds itself to avoid a close contextual analysis, the fact that it's taken 3.5 hours or whatever it is, dwelling on words like crucially or the order of paragraphs in her judgment perhaps suggests that the danger is every time we come up to this court, precisely what we do is embark on, indulge in close contextual analysis of judgments. The half a point I was going to add to now page my new single word is the point I make at paragraph 46 of our skeleton at page 176.
Paragraph.
46, my lord.
Thank you.
There were two absolutely starkly different accounts before the court. What A described, both in her ABE and by confirming that, was unequivocally repeated, significant, unmistakably sexual abuse. And what the father, both at the point of defending himself 15 years ago, but also representing him, or being represented in this trial, was putting forward was an absolute, complete denial of that. So inevitably, the court has to choose between those versions, if the court possibly can, falling back on not finding because of the burden of proof being a last resort. And
it's noticeable that in this case, in relation to H's subsequent allegations, the judge is very fair, very careful, and finds, unlike some judges perhaps, that she can't say either way, which again is quite unusual to see that in a judgment. But perfectly correct. If that is the judge's view, then that is the answer. So you can at least pray in aid that where that was the judge's, if that was the way the judge thought, she wasn't frightened of saying.
quite. My lord, of course, whilst there seems to be a criticism of the judge for taking the allegations effectively in chronological order, by the time of whatever happened in 2021, 2008 had happened. So good character reversed, it was a man of bad character. But whilst many judges would have been tempted, this judge scrupulously weighed the evidence and decided that, except to the degree that she found support elsewhere for the reason she gave, she wasn't.
So she had to make, your point is she had to make findings of the evidence she was put in front of her.
Well, that's a later point, really. This point is the judge had two stark versions. She chose between them. And Lord Justice Ryder in Riem, which was a case with significant complications in relation to the allegations. It wasn't just did X punch Y on the nose, yes or no. His lordship, and his lordship had perhaps a particularly reductive way of expressing these things sometimes, said in cases of this kind, there is often little more that a judge can say on a particular issue than that he believes X or disbelieves Y. Now, of course, this judge said a great deal more than simply that she believed X or disbelieved Y. The point we make is the textual analysis runs the danger then of expressly going behind what was said at the outset, which is this isn't an exam for the first instance judge. It's really an exercise in making a decision and explaining, particularly for the loser, why that decision has been made, and explaining with sufficient particularity to show the Court of Appeal that one hasn't stepped significantly into error, how one's reached that view. And that's exactly what this judge did, and that's what judges are for at first instance. And the danger is if great minds such as those of my learned friends in front of judges who can apply as much time to the judgment as, for example, in this case, a bigger judgment, the danger is that the good work done at first instance will be undone. So moving on, if I may, to the appeals, and I'll begin, as Mr. Toomey did, with ground 3 of his, as that seems to be the way in which that appeal's been put. We agree with the learned judge at first instance when she was confronted with the grounds of appeal and request for clarification, when she said the way in which A's evidence was described in those grounds is effectively a misrepresentation, or at least an oversimplification of what A's evidence actually was. The judge had the ABE transcript, which we know, of course, represents an interview on the very day of the final matter of which she made complaint. The learned judge had the statement to which this court has been referred, but I don't know whether the court has it clearly in mind that the statement in the care proceedings was made before A looked again at her transcript.
She made that point in cross-examination. It came
Quite.
out quite clearly.
Quite, yes.
She had seen it in January, I think, and
Yes.
after she made the statement.
Yes. So, of course, the importance of that is that those matters which A described in her statement, in relation to which she said both in the statement and in her oral evidence, I have a present, active recollection of this having happened. And also put in her mind by reading her ABE transcript, but things which she says she remembers and which in her oral evidence, when pressed on that or asked about that by others, she continues to say she remembers. And then, of course, the court has her oral evidence. The relevance of the statement, then, we say, is that the matters in it of which she claims ongoing independent recollection require some scrutiny. Now, the court, quite rightly, because perhaps it stands out as being particularly relevant and particularly graphic, looks at paragraph 3 on page 73.
Sorry, in the
Sorry,
supplemental. Yes.
So that's the before, with a great deal of detail, both detail which a first instance judge, particularly an experienced first instance judge, of this source of allegation, will be able to say this rings true in relation to what a child might be told when being groomed, also of the inducement to her. But then at paragraph 4, we have the after as well, set out in some detail, in relation to which the complainant says in turn she has an ongoing memory. And looking through the rest of that statement, whilst perhaps unsurprisingly relatively fragmentary, there is a host of detail remembered by a complainant from when she was a child, and in relation to which she said at the point of making a statement and when tested in oral evidence that she continues to have ongoing recollections of what she sets out. Both the written statement and the oral evidence, we say, suggest that the case is rather more, that A's evidence is rather more complicated, rather more nuanced than perhaps has been described. This is not a case of someone coming to court somehow with a separate, a freestanding difficulty in recalling past events. She described clearly that she remembered the before and the after, but not really the middle. But in fact, went on to give rather more nuanced evidence in relation to that. The court for example, we'll have seen at page 90 of the supplemental bundle. Against letter B, you said you remember the build up to something, you remember the aftermath of something, you can't remember what something was, is that right? And the answer wasn't simply yes, that's right, I've got a blacked out memory. It was I knew what happened, but I can't remember, like if I sort of play it back in my brain, I can't see myself doing it, no. Later down at G, the lack of memory was being put again. That applies to everything you said in the statement on the topic of sexual abuse, doesn't it? Not everything, because everything that I've said in this I remember happening.
This being the statement.
This being the statement, and the statement, even those two passages of paragraphs 3 and 4, to which I referred the court, it, not just effectively, explicitly setting out what must be sexual abuse of a child. On it goes at page 91, when some of the peripheral detail was being put, and these things I've asked you about, are they clear memories or vague memories? They are clear memories, yes. At 92, at about F, I can still remember the before and after. I can't remember doing the acts myself, but I know that I did them. I can remember doing, but I can't can't replay them in my head. And then to Judge Thain's question, like when you can play back a memory in my head, no, I can't do that. So first of all, we would say this is absolutely in line with an adult trying to recall memories set down in significantly traumatic circumstances as a child. And secondly, that Judge Thain absolutely knows that, because Judge Thain is immersed in this sort of work and will have received the training that the President sets out is to be given to judges who hear this sort of case. Of course, the exact opposite of unfortunate jurors who find themselves thrown for the first and only time into a case such as this. Nor is it the case, we say, that this is a witness who has some sort of separate, freestanding mental health issues. For sure, she described significant problems with her mental health, but she was absolutely clear in both her statement and in her oral evidence where those problems emanated, and traces them back to the abuse she received and the aftermath of that abuse, and I suppose of the trial and being told what happened in that. So, first of all, the judge was entirely entitled to say, yes, this is consistent with a child who's been abused. But secondly, it can't be used as a factor suggesting there should be greater suspicion in relation to the integrity of her evidence. It's entirely consistent with what she describes. The relevance of her standing by her account now, her oral evidence, the court has been told in terms on behalf of the father should be taken to be zero. Both in the written document and in Mr. Toomey's submissions, my lords have been told that the judge shouldn't have considered it in any way probative or corroborative of what she said as the child, that she stands by that. But we say that just can't be right. Her reason for being there, she set out absolutely clearly in her statement and then in her oral evidence. And at the very least, if the judge accepted that she meant what she said, it demonstrates conclusively that she genuinely believes that A, she was abused, and B, the abuse was at the hands of this particular man. Secondly, the fact that she was standing there, and I've made this point, saying on oath those things which she claims now to remember, means the court has on top of the memories in a transcript of an 8-year-old, also the adult saying, I remember each of these things. The other point of relevance, and because of the way the trial was conducted at first instance, it perhaps wasn't as clear as it should have been, is that many of the potential defences are not consistent with what she is saying now. There's a circularity, if I may say so, in the way in which the case for the appellant is being put. It's being said, look, this complainant can't remember the abuse because she's blacked it out. So how on earth am I fairly expected to challenge her account of it when she can't give one? But that relies on memories having been blacked out because of abuse. First of all, she could have been asked in detail about the before and the after, because she claims to have an ongoing, in some cases, clear memory of that. But secondly, and more importantly, if the defendant is right, if the appellant is right, that he didn't abuse her in any way, then it follows that she can't have blacked out memories because of his having abused her. So the various other, I say defences, that the matters set out in the proof of evidence for the Crown Court solicitors, those could have been put with every chance that she would have remembered them. So, for example, the story which was put before this judge, it seems in some detail as an explanation for her having said on the day that she was subsequently ABE interviewed as to what she saw and how she interacted with the appellant, so her walking in on him masturbating, isn't relevant only to the forensic scientific evidence in relation to what was found where, but it's also relevant to what it was that caused her to go to the police.
Again,
what it was that caused her to what? Tell her mother and then be taken to the police. If it is true that this man never sexually laid a finger on her as a girl, and if it's true that, as he speculates in his proof of evidence, she was frightened that, for example, she'd be sent to boarding school, or there'd be some other unfortunate consequence for her, and so she deliberately made up the allegation, one would expect her now to remember that fact, or at least partially to remember that fact. If it's the case that she saw those things at all, one would, and had never been abused and never been exposed to those adult male sexual matters before, one would expect her to remember that fact. And because these things weren't put, we don't know what she would have said about that. If she had repeatedly walked in on her parents, engaging in usual marital sexual activity, one would expect her to remember that. If, in fact, the appellant had never touched her, but her brother had in some way involved her in, whether you call it sexual abuse or childhood mucking about, whatever, doesn't much matter, one would expect her to remember it. But none of those things were put to her, so we can't see what she said about it. Of course, the consequence of those things not being put is that it looks as though, when one looks at the transcript as a whole, this is simply a witness who couldn't remember much of what she was being asked about. But that is because the overwhelming majority of the cross-examination was simply about what she couldn't remember. And the points at which she said, I do have a clear memory of that, and the evidence in relation to which you could be expected possibly to have memory, simply weren't put or explored. Thus it is that the complaint can be sustained with a straight face. Look, how is one supposed to cross-examine a witness who remembers nothing? But it's often the case that one has to cross-examine the witness, even an important witness, in relation to serious offences, and large parts can't be put. But it doesn't mean there aren't entirely appropriate ways to explore matters of credibility, or to explore factual matters, even if they bookend the specific act complained of, the exploration of which allows the judge to gain a proper insight into whether or not this is a witness who's telling the truth or not. So we say it's completely wrong to say that the judge could have derived no benefit from oral evidence. Stepping back, putting together a contemporaneous account, entirely contemporaneous, of an 8-year-old child, with the statement, with the oral evidence, tested in the way it was absolutely open to the judge to come to the conclusions in relation to it that the judge came to. But Lord Justice Coulson referred to what a perhaps more old-fashioned Court of Appeal might do in relation to matters not being put. Leaving us on one side, we say that the judge, in fact, went over and beyond what might have been expected when she considered the various defences which weren't ever put to the witness. But it demonstrates that the judge conscientiously accepted that her job was objectively to assess the evidence of each witness. And of course, as the judge quite properly reminded herself when dealing with the relevant legal principles, to go back to earliest accounts, written accounts, contemporaneous accounts, as being of more use very often than much later oral accounts of evidence. And if the court looks at the passage of the judgment that deals with those issues, so it's
(46, 47, 48), is it?
well, absolutely. Even though it wasn't put, the judge conscientiously considers whether she thinks it possible that this child was mistaken about the perpetrator of abuse. The force of her denial, and it wasn't put to her by, on behalf of the appellant, but others, and her mother's evidence about the absence of anyone else in their lives, the judge thought relevant. And how could she not? But given then the fact that that's what the child, that's what the now adult said, that's what her mother said, there was no other evidence to support that as being a possible motive, it's entirely proper for the judge to consider that and then to rule it out as being likely. Ditto malicious allegation, and we say that for malicious allegation at paragraph 47, of course, the fact that she now comes to give evidence, it isn't as simple as saying, Mr. Toomey does, you can't give credit to every complainant simply for turning up. Because one has to look at possible motivation for lying. The court will be familiar, for example, Baroness Hale in Re B, differentiating between, for example, sexual allegations in public law cases and in private law cases, in the latter of which there may be good or easily discernible motivation for making false allegations. In this case, the fact that 15 years on, the then child, now adult, is prepared to come to court and to say, I want to confront my abuser and I want to protect other children, is powerful evidence when the judge considers whether this is an allegation which originally was maliciously made or 15 years on was maliciously maintained. Misreporting what she observed, the judge deals with, we would say, in an entirely satisfactory fashion. And it takes one into then paragraph 49. Again, something in relation to which a judge like this will have good experience, but what contextual details is it in a child's account, which enable a fact finder to work out if it's more or less likely that the child is telling the truth. And the judge's repeated reference to these sensory descriptions, we say, is exemplary. And as the judge says, at such a young age, quote, highly compelling. Of course, that was dealing then with the objective analysis of penetrative defences. The judge went on to set out in some detail her impression of the witnesses. So if Lord Justice Ryder was right to say sometimes you simply say I believe X or disbelieve Y, this was a judge who was doing a great deal more than that, and doing so with reference to the impression she formed of various matters. So, taking it all together, we say that the suggestion that the judge misanalyzed or gave inappropriate weight to X part of, or too much weight to Y part of, the companion's evidence is entirely misconceived. She heard, or she read exactly what the child had said as a child. She heard exactly what the child said as an adult. She heard the child's mother's broadly corroborative evidence. Of course, parenthetically, I point out that matters which could have been put to A's mother weren't put, a matter in relation to which the judge expressed some surprise. But that was the way in which the appellant chose to put his case in the first instance. And perhaps it's not surprising, given that cross-examining honest witnesses about matters which they know to be untrue will yield the sort of response which is unhelpful to a respondent's case. Moving on, if I may, to grounds 1 and 2 of the appeal. The Lords have our relatively lengthy written submissions in relation to these, which I don't intend to repeat. In relation to delay, we point out what it is a Crown Court judge might consider saying to a jury, and why it is they may consider doing so. But we also point out in this case, first of all, that the judge perfectly appropriately directs herself in relation to the law, and particularly about memory, fallibility, etc. But she deals with those issues as they arise. This isn't a case in which the appellant, which A is saying, well, because of the passage of years, I don't remember things as well as I used to, or is giving a graphic account now which differs slightly from a previous account. The judge needs to know why. A is saying, in terms, I have difficulties remembering this because A, I was a child when it happened, and B, the memories were laid down in significantly traumatic circumstances. In relation, and the judge deals with that, and why she finds that not to undermine A's credibility. In relation to the father, the judge quite properly points out that whilst he complains in general terms of difficulties in remembering various facts because of the passage of time, yet in relation to each of the important issues, in particular, his assertion of the child walking in on him on that final day, he was able to give very, very detailed evidence. This wasn't a man who was obviously affected adversely by the passage of time on his memory. And of course, in his disadvantage was the fact that when represented 15 years beforehand, he had the chance to set out in significant detail exactly what he was saying about the various matters.
He didn't do that in an interview. Do we know whether he was cross-examined about that in these proceedings?
I'm sorry, in relation to...
He gave a no-comment interview, and one point that might have been taken against him is that he was keeping his powder dry to see what the evidence was so he could tailor his answers to suit.
It might have been. Lord, I think we also know that his solicitor gave evidence in the criminal proceedings indicating that she had advised a no comment interview.
Yes.
We've seen.
Well, the standard direction in those circumstances is the jury should take that into account and decide whether they think that was the reason.
Yes. And we've seen a record of a consultation between him and his solicitor at the police station, and then a further record of a later consultation. If I'd been conducting the trial, I would have put to him that the description had changed between the two of them, or at least had gathered significant more detail between the two of them. I don't know if that was put. But my lord, certainly the explanation given, we say, was obviously made up. Not so obviously, we would say it was made up, and in order to explain away, whether preemptively or after being confronted with the forensic evidence, explain away the otherwise difficult to explain fact of the semen being found on the child's clothing. Also, interestingly, exactly where the child effectively said it would be found on the appellant's bed. I'm not sure I can expand in much greater detail on what we say in relation to delay. First of all, if it said that there's some standard direction that family courts should give, then we would urge this court to go nowhere near that sort of suggestion. The wide canvas, the fact that the family court judge looks at, hears everything, hears all the submissions, means that there's no standard direction that would be apt in the circumstances, and we would fall then into the danger of seeking to import criminal law concepts created for different purposes, that is, to deal with the problem of a lay jury dealing with issues into family matters.
Well, there isn't even a standard direction in criminal cases, as my lord pointed out when we were looking at the compendium. It depends. I mean, sometimes there will be a specific and clearly potentially prejudicial missing bit of evidence. Medical records is an example, and specific directions are then required. Otherwise, the trial would not be fair. But they're always tailored to the facts of the particular case.
Well, yes. I mean, we made that same point in our skeleton argument when we considered what it is that judges would be saying to jurors. Of course, we also made this point in the document that almost all of those directions to the juries, whether they're standard or whether they're tailored, would end up with the words, members of the jury, you must give this such weight or relevance or whatever else as you see fit. So it's giving the jury the obvious, but perhaps not to the jury, direction, but then leaving it to the jury. So the judge will be directing themselves in those terms doesn't solve the problem anyway. And also reference to missing evidence, that's ground two I was about to come on to.
Yeah.
We say certainly, in fact, one of the criminal cases that we cite refers to the need for a Crown Court judge to consider whether there's a general assertion that there might be some evidence that's now missing that would be helpful, as opposed to a specific pointing to a particular type of evidence, the absence of which is disadvantageous or prejudicial to the defendant in a criminal trial. And in this case, we make 2 points. First of all, what is missing, and secondly, to whom is that prejudicial? So for sure, we don't now have the video of the ABE, and we don't have a transcript or other recording of A being cross-examined, however that took place in 2008 for the Crown Court trial. In a criminal trial, even if there is specific evidence that's seen to be missing, it's easy to say to the jury, effectively, that the benefit of any doubt should be applied to the defendant because of the imperative in a criminal trial for there not to be a miscarriage of justice. But in a family case, how we ask, could that be applied? Because, just taking, for example, the absence of the video of the child and her cross-examination, we know by virtue of the hung jury, I think I've got this right, that between 3 and 9 members of the jury were sure of the defendant's guilt, and the others weren't. Applying that to this, how can it be said to be disadvantaged to the appellant, as opposed, for example, to the local authority or any other party, that's now missing? It may be that the cross-examination and/or the video were entirely compelling. It may be that the demeanour of the child, descriptions were such that it would have shored up the local authority case, or it may be that it would have assisted someone seeking to undermine the allegations. But the simple fact is that we don't have them. The judge is bound to try the case on the evidence before the judge.
Well, there is a sort of echo, isn't there? I've heard an echo, a very faint echo, of the old rule that the more serious allegation, the more cogent the evidence required. The pre-B, I'm just about old enough to remember that, Mr. Tyler, the pre-B rule that
Yes.
derived back from Mr. Justice Ungoy Thomas in some case. My Lord is chuckling because he remembers that authority. Oh, very well. It goes back to the more from a fraud case, wasn't it? The more cogent the evidence, the more serious allegation, the more cogent evidence required to overcome the improbability of it. And that was, for some years, that was the principle in family cases. And it's gone now with Warby and the simple burden of proof and the binary. And
Indeed, and we were given examples of pendulums and different sides of scales by different judges trying to teach us all how those principles would work.
Well, the judge has to work. The judge has now to evaluate the evidence on a simple basis for the evidence that he's got.
Yes.
And of course, there will be cases where he or she concludes the evidence isn't sufficient.
Yes,
So that's really what Mr. Toomey is saying here, isn't it? The evidence wasn't sufficient. That's what he has to say, really.
well, yes, although looking at grounds 1 and 2 of the appeal and the skeleton argument, it seems to be going rather more than that, saying that a respondent in a case such as this is a quasi-defendant and should be given the benefit of the doubt that defendants are given in a criminal case. The point we're making...
That's why I say there's an echo of the cogency.
Indeed, indeed. Whereas the simple question is, unless the evidence that we do have is inadequate to allow the judge to make a finding, then the judge has to make the finding on the evidence. It sounds almost too obvious to point out, but to speculate about what might be in the evidence that we know we haven't got takes us nowhere, because there's no obvious person in relation to whom the benefit should accrue. The skeleton goes on to say, and it wasn't put by Mr. Toomey, but I'll deal with it because it's there, that the court should even consider what evidence we don't know to be missing, which caused me to...
Hence your Rumsfeldian
chaos.
reference.
Yes. Because this is just to create a satellite litigation and a bog of confusion, whereas the judge said when confronted with the request for clarification, the evidence on which I made my findings was the evidence, which was bang, 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 and she set it out. Now, it may be, for example, if we didn't have the transcript and if A had died or couldn't give evidence, and all we had was, I don't know if my lord recalls those handwritten notes of A/B interviews that might be filled in at the time before the interview is properly transcribed. It may be, if a local authority came to court with just that, a judge would say, well, look, I can see that serious allegations were made, and it's perfectly possible that they were properly made and they represented accurately offences that had taken place. But the paucity of the evidence, the poor quality of the evidence is such that I simply am not in a position.
If they lost the transcripts in this case,
Yes.
as well as the video.
Well, yes, but in such a case, if one injects also the fact of a trial that went to a verdict and an acquittal, let's ignore the hung jury point, but that might make a difference.
Yes.
Because then you've got some roughly contemporary or more contemporaneous material which goes the other way.
Yes. Well, yes.
So I think what Mr. Toomey is saying is that this case is closer to that than your example. You've got that background. where we obviously can't look into the jury's minds. We don't even know what the submissions made were, and we don't know about a lot of the evidence, but we do know that they were not convinced, so that they were sure of any of the charges collectively.
Yes, we know that the majority weren't convinced, so they were sure.
Yeah, there was no, we don't even know whether we were given a majority verdict, but not as many as 10 of them were convinced of all the charges, or of any of them.
Well, yes.
It doesn't-
in that context, and he's saying on facts. In this case, that is a factor that goes in when you're evaluating the importance of the absent evidence, the nature of which we know.
Yes.
I don't think
You
it's,
say it's on the facts. It's all about the facts of the case.
It's all about facts.
and I don't think it detracts from your submission, but it doesn't necessarily follow that 3 to 9 were sure of guilt, because obviously some juries, like this judge in relation to the more recent H allegations, not the shaving, but the other allegations, couldn't decide. Some juries end up in that position. So some may be sure, some may not be sure, and there may be a don't knows in the middle.
Well,
So,
yes.
I mean, but it doesn't detract.
You don't know
from
anything,
the
you don't really know anything about ground court, do you?
No.
I mean,
So-
for my part, I think it'd be jolly risky for any, I know the judge referred to it at some point, but it seems to me not to be particularly helpful to consider, to speculate about what happened to kind of jury. We don't know.
Well, we entirely agree, and that's why we say that the judge's self-direction was exemplary on that. The paragraph was paragraph 30 of her judgment, where it looked like there was some ambiguity. I wonder really whether that should have been 2 separate paragraphs. It seems fairly clear.
Paragraph 30.
No, I've got that wrong.
Lucas, we haven't got to worry about Lucas yet. There was a paragraph. We looked at
Paragraph
earlier.
20, my mistake.
20.
Yeah, so page 46.
Yeah. Yeah, so she says it's all irrelevant.
Yeah, she says the fact that he was acquitted on one count, hung on the others, carries neither weight nor relevance in these proceedings. And that must be so, given that it's taken a few minutes even to debate how many jurors might have thought what in relation to trial that we know nothing about. If then, from similarly downwards, one reads it's a separate paragraph, it makes perfect sense. Similarly, the views, i.e. in relation to character, guilt, etc., expressed by other witnesses, be they police, family, friends, adds no value to the evidence. They don't have access to the will and array of evidence before me. Perhaps there are cases when the views of others would be of assistance, but this isn't one of them, when confronted, as the judge was, with 2 completely different accounts, and where the judge had enough other material and power of reasoning and tested oral evidence to choose clearly between the 2 of them. That's what we say about missing evidence. I can expand on it more if needs be, but I'm not sure I can add to what's in our skeleton argument. Good character. If I may say so, the argument seems to have morphed fairly significantly from the point it was put to Judge Thain through application for permission, the skeleton, the replacement skeleton, and then the submissions just given. My understanding, having pulled up the submissions, the written submissions from Judge Thain, is that good character was put in this way. The father's 58 years, he has 3 convictions for theft recorded against him on this date when he was this age. He pleaded guilty. No convictions or cautions recorded against him, or no other convictions or cautions. In such circumstances, the court should treat him as a person of good character. It's submitted that this would be in accordance with the established principle in Crown versus Vi, which is a 1993 case, approved by the House of Lords in Crown and Aziz, which is a 1996 case. A judicial self-direction is therefore necessary as to the relevance of the good character of the father. Knowing that that's how the matter was put to the judge in submissions makes the judge's dealing with that eminently explicable.
Is that in the bundle? Is it that?
That's not, my lord. I had to pull it up when my lord asked in terms whether good character was relied on in front of the judge, and it was, but with reference, albeit outdated, to 2 Crown Court or criminal cases in relation to good character directions. And of course, the judge sets out in terms that she considers that good character, which I guess is her shorthand for what was being put under the heading good character in the written submissions, has no relevance in family court proceedings. But the other factors which genuinely militate in favour or not of findings do, and parenthetically, to the extent that they do. So of course the court will be familiar with inherent probabilities and how that's dealt with now post B, and whether the quadruped in Regent's Park is a lion or a dog, depending on whether the gate's open, etc. These matters will impact on the judge's decision to the extent that in any particular case they do. That's the opposite, really, of how things feature in the Crown Court, where defendants are entitled as of right to a direction if they fall into one category or another. I'm not sure it's still being asserted. It seems to be in the skeleton argument that there ought to be a close alignment between the family court and the Crown Court in relation to this. We say absolutely not, and just point to quite how complicated the 9 pages in the compendium are, and how utterly complicated the 5 different categories of the Vice President and Justice Hallis are in the Hunter case of different types of good character. We make this more general point.
My lord sat in Hunter as well. You may remember that.
Very well. So when I said
Anyway.
complicated, I meant the 5 erudite categories set out in
Too
Hunter.
late, Mr. Tubman.
Which ones in particular were you saying erudite?
2 and 4.
The 5 categories that are in the previous authority. The point of Hunter was to try and reduce, or as far as possible,
Distill.
eliminate
Simplify, clarify.
complexities. And one point was the one that I put to Mr. Toomey, which is that you don't get a good character direction if you're not of good character, as Lady Howard used to say. So one of the problems in this case is that you could go and argue to a Crown Court judge, look, I've got some old convictions for this, obviously, disregard those because they're old. 20 years have passed, and the Crown Court judge might turn around and say, I'm not going to do that, and the Court of Appeal would not interfere.
Well, yes. Another complication, though, in a family case is that there is no defendant. We don't accept that a respondent is a quasi-defendant. So if the purpose of a good character direction is just to make sure that a person who is facing the state through the Crown, accusing them of an offence, conviction for which will lead to ignominy and punishment, is entitled to say to the jury, I've done nothing wrong before, therefore you can believe me on oath, and therefore you can consider that I don't do this sort of thing, then, and I'm entitled to that benefit, then in relation to whom should that sound in a family case? Because if the court has to, it is bound to get as close to the truth as it can do through the fact-finding process. It's the underlying truth of the allegation that's important. So wouldn't a complainant be entitled, or wouldn't justice be served by a complainant also saying, I have no previous convictions, therefore I'm more likely not to be lying to you, and guess what, I haven't previously been found by a court to make false allegations of sexual abuse against somebody, and every other witness a fact. The point we make is things happen a certain way in the Crown Court because there is a single, or at least a single group of people sometimes who are the defendants, and because the principle of being happier to acquit the guilty than convict the innocent is absolutely embedded in those sort of trials. In a case where the test is the preponderance of evidence, balance of probabilities, and in which the court has to survey a wide amount of evidence and hear from all sorts of different competing factual witnesses, it would just become absurd and unworkable to import anything remotely similar to a quasi-criminal test of good character. The extent to which good character is relevant, we would respectfully agree with Lord Justice Baker in my Lord's observations, I think to Mr. Toomey, that absolutely as part of the overall balancing process, weighing the evidence, sifting the evidence, was Lord Justice Wilson, as he was description of sealing the evidence, seeing what solid factual averments remain to be considered. As part of that complicated process, then the fact that someone has or hasn't lied previously, or has or hasn't committed X sort of offending previously, may be relevant. Or it may not be. It may just be an affront to common sense and or a waste of a paragraph or two of a judgment to make any comment to it if the evidence is otherwise overwhelming. And of course, we make the point in this case, there are two sets of allegations, 15 years apart. To import anything like a test of good character would mean that the judge looking at 2008 would have to say, well, by this stage, the appellant respondent was 40-something years old, and so was entitled to a good character direction. By the 2021 allegations, the judge would say, depending on what I've just found about 2008, he is either entitled or not to a good character direction because he either has or hasn't, 15 years earlier, abused a stepdaughter. What if the judge was looking at the allegations in the other direction? What if, for example, there was overwhelming evidence that the recent allegations were true, but the judge was in more difficulty determining the truth or not of the older allegations? Should she effectively direct herself that this is a man who at the time 2008 was alleged hasn't previously offended, but who I happen to know 15 years later is going to offend in a similar way to a similar child? The point we make is it's just too complicated. You can trust to the good sense of judges with vast experience in assessing the whole canvas of evidence to come to the right decision in a case like this. Just a final point, and of course it wouldn't affect what the court would do, but anything approaching a good character direction would presumably leave subject to scrutiny any number of previous decisions of the family court where a similar test in a similar robust fashion hasn't been applied. Courts deal with credibility by looking at everything and a far wider range of evidence, dealing with a far broader range of a person's life than in any usual circumstance a jury would ever do. That I think then is ground 4. Ground 5, I wonder if I could refer the court first of all to our skeleton argument, please.
Yeah.
Page 187, paragraph 88.
Where you set out the facts.
Well, yes.
Yeah.
And I know laws have been taken to them, which is why I look at them here. But so you have what the two girls have said. And it may be that they're not word for word or act for act the same in what they describe. But you have two teenage, looking at the photographs, presumably certainly pubescent stepdaughters. One saying in a shower, one saying in a bathroom without specifying where, but the latter of those saying she had no top on, being shaved on more than one occasion by the appellant. So those are the factual assertions made by the girls, and they're feeling uncomfortable about that fact. The parents' plural version was markedly different and had in relation to shaving a single occasion for each girl as part of a rite of passage type training exercise. This is how you use a safety razor without lacerating your armpit or leg or whatever else. So a clear factual dispute between the two sets of evidence, the judge commenting that the mother's evidence seemed to parrot the father's in this, as with many things. The judge deals with this before we get to the part of the judgment that's complained about at paragraphs 82 and following of her judgment. First of all, at paragraph 82, there's a description of what H said. The context of that, no, so I'll come back to that. Of what H said, The word support is important as to how she describes the relevance of S's evidence. She's not talking about corroboration in any legal sense, but simply refers to the fact that separately the two girls have given accounts with broadly the same factual substratum. Paragraph 83, the judge quite rightly considers collusion. Of course, it's extremely important that H's account focused on a huge amount of sexual abuse. It turns out not found by the court have taken place. S's doesn't. So to talk of collusion would make not much sense, given the only matter about which there is support for H from S is this. But then you have a paragraph 84, the judge is dealing with what the parents said. And this, I venture to suggest, is really the stuff of what my Lord Justice Baker was saying in that case about the importance of parents' evidence. It's this sort of analysis. This is where the Piglovska advantage really assists the judge. The father denied walking into the bathroom whilst the child was showering, so a clear distinction there between the child's evidence and his. Unless sometimes, once or twice, she's called me in to get her the shampoo or to get a razor. There's a curtain there. I put my arm in the curtain and she takes it. The judge then sets out what presumably was explored in cross-examination. It's not clear why the father would have done that, given other people in the house. She mentioned that the judge said the first time he shaved her, there was a bikini. When asked why the mother didn't do it, that description was given. The father, fourth line down on page 71, denies shaving his stepdaughter or going into the bathroom on any other occasion, but then said, I'd only go up if she called me or if she cut herself or something, but she'd always be wearing something. I'd always say to her, have you got your bikini on? And then the judge, we say, unsurprisingly, expresses her struggle with the suggestion that a teenager would cut themselves in a shower, feel the need to call an adult from downstairs, but put on a conveniently prepared bikini before the parent came upstairs. The judge also then set out significant changes to the account by the parents in their oral evidence. And again, this is a matter in relation to which we say an assessment of the parents' evidence is entirely justified. The disconnect between the mother saying on the one hand it's perfectly normal for a stepfather to shave his pubescent teenage stepdaughter, but on the other hand expressing shock when she was asked if her father had done that to her. So even those paragraphs there are necessarily an imperfect description of the evidence the judge heard, because this is a 20-page judgment, not a 400-page judgment. But that is an assessment, a description, a summary of what the judge heard, before she then comes on to her dealing with that at paragraph 104.
And what's saying against you here, cutting to the chase, is that the judge wrongly said, Mr. Toomey said, that S had insisted, both H and S had, the father had insisted on coming into the bathroom when they were showering and shaving their legs and when they're naked. All things, and ring them, which
Yes.
Mr. Toomey says S never said.
Well, we know what S did say. So whilst the word insisting might be more exaggerated than what she had said, she certainly describes him coming in when she neither needed nor wanted him. The context of this paragraph is important because it follows the judge's painstaking, and we agree with Lord Justice Coulson, extremely and eminently fair approach to the other, more serious allegations. So going through all of those, she ended up finding them not proved. And then in relation to this, at paragraph 104 of her judgment, possibly slightly factually misdescribed what S had said. But it comes, doesn't it, to this. H described him coming in when she was in the shower and shaving her when she didn't want it, that being ongoing. S described him coming into the bathroom, not explicit where she was, when she had no top on, repeatedly, but until she told him to stop. And the parents gave evidence which was A, inconsistent with that, and B, internally inconsistent, they changing their accounts. So the judge was only dealing, of course, with H's allegations, perfectly justified in saying, for the other allegations, I wasn't quite able to find them proved on balance because, in particular, the difficulties in relation to H's credibility. But in relation to this, I find supporting evidence in the fact that another teenage girl in the same house, entirely independently, talks of him doing this thing to her. And that lends sufficient support to H's account for me to find that the burden of proving it has been discharged by the local authority. And having got that far, given what the two girls said about their state of undress and this happening repeatedly, it's no surprise whatever that the judge attributed to it a sexual motivation. And it matters not that S didn't describe this as sexual abuse. She came up with, she told the authorities about this in answer to a question dealing with sexual abuse. And the fact that it was sexually motivated didn't mean it constituted abuse unless he touched her in a way other than shaving with which she wasn't comfortable. But we say it's a finding absolutely open to the judge. And she explains how she got there, which was not just the port between the girls' accounts, but also a proper analysis of the parents' respective accounts. And so again, absolutely and completely the stuff of a judge's discretion. And the fact that at the end of a long judgment, there are 4 tiny errors which great legal minds on the appellant's behalf have been able to find on, we would say, a close textual analysis of this judgment, doesn't undermine the sanctity of that finding. My lords, moving on, if I may, to the mother's appeal.
Yeah.
I wonder whether the first ground is most easily dealt with to start with by looking at the judge's clarification judgment. So page 115.
Yeah.
Paragraph 15. So turning to the permission appeal document, ground 1, finding 2. I'm afraid I fail to understand how this particular ground is argued, because the key word within this is the mother has failed to consider the possibility of it being true. It was a mother's view, not disputed, these were lies. She reached the view immediately on being told. It's been unwavering in that particular position, stance throughout these proceedings, and indeed in her own admission.
I think what Mr. Larizade was really focusing on here was that even if it's right there was a possibility, if it's right that the mother failed to accept there was even a possibility, in the circumstances that didn't amount to a failure to protect.
Yes. Well, I wonder whether the problem simply is the finding is shorthand. The finding as expressed is shorthand for the actual finding, which you will see at paragraph 109.
Of the judgment. Of the main judgment.
Page 81.
Yeah.
Or beginning at 109.
Page 1, paragraph.
So I'm so sorry, page 81, paragraph 109.
My mistake.
So paragraph 109, the judge, again, we would say eminently fairly, any judges wouldn't have done, said the mother was entitled to rely on the acquittal and the father's description. And then said, 110, I'm deeply troubled by her response at the points that H raised the allegations. Given the history, the fact that her own daughter had raised an allegation should at least have led to some curiosity about whether there may be a need for concern. The undisputed evidence is the mother immediately rejected her daughter's allegations as lies, proactive in undermining her accounts and seeking her husband's return home. At no stage has she been prepared to consider the possibility that the allegations may have been true. So that effectively is the judge's.
So what passage were you particularly reading from then?
So that was paragraph 110.
Yes. Oh, good. Right. Yes.
It goes into 111. That she told police immediately on the day of arrest that H was lying. Maintained that through discussions with social workers. It's in that context that the criticised passage about demeanour is set out. It doesn't look, if I may say so, remotely conclusive in relation to the judge's decisions. It's simply part of her overlying unease, and less important than the vehement denials and undermining of her daughter, presumably in the judge's mind. But it leads to 113, which is effectively the finding. I'm concerned the mother has been incapable to date of accepting even the possibility that F may pose a risk of sexual harm.
So this is the perhaps the confusion. The finding is expressed in the findings at the end of the judgment. It's under the heading, the mother failed to protect H from sexual harm she suffered. And then and then 2 is where we've been reading from.
Yes.
As expressed in 113, it's looking towards the future. It's
Yes.
the risk of future harm. There's a risk of future harm to all 3 children by reason of the mother's failure to protect.
Yes. Well, this is why I say in our skeleton, it's perhaps a welfare finding rather than a threshold finding.
Yes,
as a matter
you
of
did say that.
technicality. And the reason it's under the heading failure to protect is the judge, again, conscientiously was going through the authority schedule, not making various findings. So if she'd made the finding that before the allegations were made, the mother culpably failed to protect, or culpably failed to acknowledge the possibility that her husband posed a risk to her daughters, then it would be a failure to protect, properly so called. Because she fairly didn't do that, but said, however, the mother's behaviour and reaction from the moment of the allegation has been of concern throughout this period for all these reasons, it's a likelihood of failure to protect.
So really, we should read 2.2 on page 88 of the findings. This is the findings at the end of paragraph 122. We should read that finding by itself without the heading, the mother failed to protect H from sexual harm she suffered.
Well, yes.
She's making a finding there. She's making a finding there that the mother, from the moment of H's allegations, failed to consider the possibility that they were true. That's the finding.
Yes.
And that's part of the findings upon which she's concluded the threshold was crossed. Of course, there's the findings against father
Yes.
as well. And the findings which are in respect of the treatment of H by the mother, which is no longer seems
Yes.
pursued on this appeal.
So
So
the
those
fin-
are the findings going forward, which the judge will have to evaluate in light of any future assessments.
Yes. So the findings in relation to which threshold is crossed are those which existed as at the relevant date. So there would be the fact that A had been abused X years previously would mean at the relevant date H and
Relevant
others.
date being the start of proceedings.
Yes. Well, unless, yes, effectively.
When was it? So that yes, was that? What was the date of start of proceedings? Was it when H made the allegations, or more or less about that date?
21st of February.
I don't want to take time if this is going to just.
21st of February was the issue of proceedings. In fact, protective measures, I suppose, have been put in place before then, so there may be an argument about that. But at the relevant date, A had already been abused. We now know by the judge's findings.
So this is not a threshold point. You're right. To come back to your point, it's a welfare point.
Yes. But it's a finding that's perfectly open to the judge. But of course, paragraph 113 gives it context. This isn't a threshold cross because of this, because of the way you reacted to this, the state's entitled to intervene. It is, given my findings, I will require considerable reassurance of a shift in her position before I can be satisfied she's able to keep her daughter safe in the future.
So is the cross-heading in italics in above paragraph 112, what sort of 122? That comes from the threshold document.
Yeah, that will be. That
That's
should have
a
a two.
quotation from the local authorities' allegations rather than itself a finding by the judge, it's just the context in which she's making one of the findings that she
Well, yes.
puts out.
That should have a 2 before it, shouldn't it? All the other italicized headings have numbers before it. That's number 2. Is that, I haven't checked. Is that how the local authority put it in their threshold? That's how you put it in your document.
It must be. Well, this is.
Yeah, okay,
It,
fine.
it seems that the judge is reading, having given her findings.
Yes, absolutely.
in
She says
narrative
out
form.
proved, not proved, proved, not found. So it's repeated verbatim with proved or not proved, with the qualification that she makes in 2.2.
Right. So if there's necessarily a degree of imprecision, if the finding needs to be slightly changed, I'm sure that'll be uncontroversial, but the core finding is there. The mother's behaviour, by the point of judgment, since the point of the allegations, was such that the judge was significantly concerned about her ability to protect. And of course, that has involved the mother immediately saying that H lied, maintaining that throughout, mounting a very active case in relation to that, for example, finding those TikTok videos, and right up until today through Mr. Larazade still maintaining a stance. It's not fatal, presumably, but the judge was entitled to say at 113, I'll need some persuasion that there's been a shift before I decide that this is a mother who can protect from, I imagine, sexual risk generally and sexual risk from this man in particular. My lord, I wonder, given the time, if there's anything I can add to how we respond to Mr. Larazade's other grounds, such that they're still maintained to what's in our skeleton argument.
No, I don't think so, because he was very realistic about the points about the mother's treatment of age, and I think you dealt with the other material either in those submissions you've just made or in writing. So certainly speaking for myself, I don't recall.
Well, thank you. I suppose the only final point then in relation to the sexual risk from the shaving, the judge was corrected at the point of the clarification hearing in relation to what S said. S saying, well, the mother was aware of this, and the judge, we would say quite rightly, said, well, if she was aware of it, and this point was being raised effectively on behalf of the parents, if she was aware of ongoing shaving beyond the single bikini-clad instance that she told us of, then that is even more concerning from an ability to protect point of view. But really the fine detail of those findings, given where they come in context, having dealt with and not made findings on that huge tranche of far more serious sexual allegations, we would say is effectively neither here nor there. What's important are the core findings of the father's behaviour and the mother's rejection of it.
Yeah,
May I just step back, please?
please do.
Lord, my lord, you need to turn to it now, but page 24 of the supplementary bundle is the consolidated schedule of findings sought, through which the judge, I think, pretty clearly was reading here. And of course, it's repeated in the order emanating from that April hearing as well.
Yeah. Thank you very much,
Thank you.
Mr. Tyler. Mr. O'Brien, we've obviously got your skeleton. Is there anything that you want to, any submission you want to make orally?
Well, my lord, just in terms of the last points that have been made about the risk the issue of risk, because that's a matter which concerns the guardian in particular.
Of course.
The finding that the judge made about the mother's attitude potentially could have gone to threshold. My lord, if your lordships look at Re G 2001 2 Family Law Reports 1111 paragraphs 11 to 15, that is where Lady Justice Hale dealt with the timing of when you assess risk.
Yes.
And you can take into account material that comes after, including events that happen subsequently,
Yes.
in terms of reasoning back where the threshold was found at risk. So, for example, if there's a domestic abuse incident, subsequently, the court might say, well, that tells us something about what was going on in the household at the time. In this case, what the judge was considering was, what is this mother's reaction to serious allegations as they evolve, and even now, she says, the father isn't a risk.
But you say if we allow the father's appeal completely, the threshold would still be crossed on the basis of evidence as to what happened subsequent to the relevant date.
Well, yes, because it could be. I'm just saying it is analytically, my lord, it might have been better now in reflection, having listened to the argument, if the judge had been invited to consider her finding at 2.2 under category 4,
Yes.
where she deals with
ENT.
yes, because the second aspect is that Section 1.3 of the Children Act requires the court to consider the risks of harm and also as a welfare issue. And so this finding, if a judge during the course of a fact-finding hearing about threshold realises that there is a finding which needs to be made which is relevant to the welfare evaluation, then the judge should make that finding.
Yeah. In fairness to Mr. Bain or whoever drafted the threshold document, as drafted, the threshold document, of course, 2.2 was that the mother was aware of the previous allegations and had failed to take appropriate measures way back. But the finding made by the judge was only since H's allegations. So it was at that point that it arguably should have been rejigged under 4.
Well, as a matter of history in this case, there was a pre-trial review, I think the 2nd of January 2023, following the local authority amending their allegations. But at that stage, whilst there was, as I'm looking at documents, whilst there seems to have been complaint about how are we going to be ready for a hearing on the 23rd of January, there was no application on the basis that this is inherently incapable of providing a fair outcome. And one of and that reflects in my submission the caution that has to happen where you have material from another set of proceedings, in this case they have to be criminal proceedings, which is only partial. It's potentially relevant to welfare, to findings which are ultimately only done because they're going to inform the welfare evaluation. And the court ultimately has to decide on the material that it has got.
And of course, I dare say we haven't looked at it, but in the early stages, you had no idea what you were going to get for the 2008. Presumably, it wasn't clear how much survived until.
Well, you could have a. Sorry.
No, the authority were hoping more was going to emerge.
Well, and of course, you could have a situation where you have a historic allegation in which it never went to an AB interview at all. Yeah. But everybody finds that the adult who comes along and says, I had this experience as a child, gives compelling evidence. Now, there would simply be, there wouldn't be no argument about, well, we haven't got an AB interview, we haven't got a trial. There would be nothing. It would simply be, all these things are ultimately tools to assist in the discernment of what is to be believed by the tribunal of fact, whether it's a jury in criminal proceedings or the judge here. So, Lord, in my submission, the only other matter which I wanted to raise, when your lordships look at the decision of RIAR about the appropriateness of incorporating concepts from the criminal jurisdiction into the family jurisdiction, the analysis, which in that decision at 62 to I think 67, makes it clear that fundamental to this is the evidential basis, the evidential principles are different in family cases and in criminal cases, I mean, no more strikingly than the completely different attitudes to hearsay, which you can see in this case because of the we've got the admissibility of hearsay is much more widely.
Well, we don't want to get involved in all that.
No, but what I'm saying is that the decision in R makes it clear that fundamental to why there should be a reluctance to import criminal concepts is because the purpose of the exercise is different and the evidential principles upon which those are exercised are different. My Lord, I would derive that from the decision, but I'm not going to take you through the passages at 4:30. My Lord, those are the matters I wanted to raise.
Thank you very much. Yes. I was going to ask you if you'd like to go first, if you've got any points in reply, and end with you, so that since you're the main burden of the appeal, you should go last.
My Lord, I have made my submissions both
You
in
have?
writing and orally, and I don't wish to add to it.
No. Well, I think it, certainly speaking for myself, there wasn't anything that was raised in relation to your appeal that was new.
Exactly.
So I think that's fine. I mean, that's my view of the father's appeal as well. But Mr. Toomey has obviously got an opportunity to reply.
Thank you.
So thank you very much. Yes.
Just a couple of points, if I may. We are not seeking to deploy criminal concepts by this appeal. We're simply inviting the court to import a process of reasoning which is equally valid in a civil court or in the family court to adjudge their undertaking an assessment and evaluation of evidence. We would reject the characterisation of this of the respondents to ground 2 as being one where we're inviting the court to approach a respondent as a defendant. In relation to ground 4, we're not asking for good character direction. What we're asking for is a family court judge to take into account all known about a parent, including matters relating to their character, and to develop the criminal analogy that Lord Justice Warby raised with me earlier, that it may well be the case that a man with a previous conviction for dishonesty does not receive in the criminal court a direction of good character. But what would likely follow, and would certainly be appropriate in a family court, is that that evidence would be in the criminal court adduced on his behalf with the view to explain, to say to a jury, that's quite a different matter, it happened a long time ago. One wouldn't have that process in the family court. What one would have is a judge with all the information before him or her, which would include that previous conviction, and that too would be weighed and balanced, not particularly differently to the example in the criminal court if the defendant introduced it in the absence of good character direction. In relation to ground 3, we just remind the court that whilst it's right that the witness statement of the complainant was made before she read her ABE interview, it's clear from her evidence that she had much earlier spoken to her mother about those matters, a pastoral care worker about those matters, and had undergone therapy. And then finally, in relation to ground 5, where Mr. Tyler complains in that ground and elsewhere of our invitation to this court to undertake a close textual analysis. If a close textual analysis reveals obviously and significantly misdescribed matters of evidence, as well as an error about a corroborating witness, in this case the mother, then we would suggest, we would say a close textual analysis is required. The analysis of those important differences between the account of S and the account of H goes to the heart of whether the motive was benign or sexually motivated, whether the actions were benign or sexually motivated. Well, those are the only points I wish to make in reply.
Yeah, that's very clear. Thank you very much. Fine. All right. Thank you very much. Thank you all very much. We will be reserving our judgments, not least because it's 25 to 5. You will get a draft. In relation to that draft, you are welcome to correct typographical errors and any minor factual errors in the judgment that we send out. You are not welcome and are indeed positively disencouraged to re-argue the case, because any re-arguments of the case will end up in the bin. So it is not a review process, it is simply that the judgments that eventually become the final judgments don't contain, as I say, either any minor factual errors or typographical errors. Those draft judgments, we can't say when you'll get them. We're towards the end of term, so there's always a bit of a backlog. So we will do our best to get them out to you as soon as possible. My clerk, if he's not already done so, will have a list of those people who will get the draft judgment. It's not to go to anybody else. As you know, there has recently been a certain amount of disquiet about draft judgments being disseminated beyond those who are supposed to have them. And as you probably know, that is regarded as a contempt of court. I'm sure you all heard this homily hundreds of times already, but I have to give it just in case there are people who have not heard it. It goes to the people on the list and nobody else until it becomes a final judgment. Thank you all very much.
All rise if able.